the rest to those who should be doing what they should be doing. So we've built up over the last 3 weeks, or this is the third week rather, into how perhaps differently to approach trial advocacy. And we started off with the general discussions about finding and building a narrative, and then last week Monday, dealt with how to approach examination in chief in a more mindful and more constructive and more considered way. Cross-examination is an interesting little beast. I think it's the one that we all wanted to do and thought would be the most dramatic and the easiest to do, because pretty much we grew up, I would think all of us, watching something either on TV or satellite or streaming or whatever it might be that involved legal programs with fast-moving, silk-tongued lawyers, generally American, sometimes irascible Brits, who would cross-examine, who would shout and scream and throw objections all over the place and eventually break the witness, generally just before the credits rolled. And we thought that was brilliant and that was great lawyering and that's what we all wanted to do. Of course, when you have your first couple of appearances, whether it's in a tribunal or a court, you come face to face with the reality that cross-examination in South Africa certainly is nothing like cross-examination on that what we've seen, and we've been coded in the wrong way. We've been taught to approach cross-examination as if it's cross-examination and not as a forensic tool that should be deployed in very specific ways with very specific objectives to achieve very specific results. So I want to go right back to the beginning and perhaps advance different ideas about why we do not cross-examine, why we shouldn't cross-examine, what our objectives shouldn't be, what they should be, and how best to go about them. I've certainly come to a very different view over the 20 years I've been at the bar of how best to cross-examine. That is very different to how I did it before. So let's start with the notion of cross-examination. I'll start this from the beginning. Part 3, what is the point of cross-examination? Now we all do it because we have to do it. Examination in chief finishes and we stand up and do our thing. But what is its point? Now, I focused a couple of minutes ago on the word cross-examination, but of course the point of cross-examination is not to examine crossly. It's not to argue. The arguing happens later. It happens when the witness is out of the witness box. It's not to win against the witness. And I think it's important to start there, because if you approach cross-examination adversarially, if you approach every witness you're going to cross-examine as if they are the enemy, as if they are lying because they happen to be the opposing witnesses, you put yourself in a very dangerous mental space that then drives the kind of confrontational cross-examination that almost always is not as successful as a considered and thought out, controlled cross-examination. So if the point of cross-examination is not to do those 3 things, is not to go into battle, as it were, what is the point? I would suggest to you that there are only 3 reasons to cross-examine. It is to undermine, underline, or explain. That's the only reason we should do it. And we cross-examine on purpose, not because it's some automatic response. So let's go through those 3, because you'll see none of them are fight, prove, lying, win the battle. They're very specific and intentionally understated terms. So what do we mean by underline as opposed to destroy? Well, if your purpose is to chip away at your opponent's case, then you are undermining that case. You are cross-examining for the specific purpose of undermining what has been advanced in cross-examination. And you've got to then know that that is the purpose that you seek to achieve with a witness. And of course, as we will talk about a bit later on, your purpose for different witnesses will be different. But undermining is not necessarily the same as destroying. And if you go into a cross-examination where your objective is to undermine, slowly, gently, in a very, very structured way, and you gently chip away at an argument, question by question, statement by statement, your objective is that once you've undermined sufficient of the walls that we talked about last week, or the foundation, if you want to murder the analogy, the case will collapse, the structure will collapse, or will at least not be as strong as it was before. And that's not a bad outcome. It's unrealistic to think that in cross-examination, you have to destroy. Sometimes raising doubt, raising a question is enough. And again, you've got to know what it is you want to achieve. Underlining is very different. That is cross-examining to underline a point in your case, to use the opposing witness to underline a point in your favor. And if you're going to do that, of course, the best way to do those kind of things is not confrontational, because you want the witness to agree with you. You want the witness to give the concession willingly, if at all possible. So then you know, when I'm cross-examining this witness, what I'm trying to do is to get from them enough info to build up, to reinforce, to highlight, to underline parts of my case. It is a positive outcome, not a negative one. Much like explaining, there are often circumstances where something comes out in cross-examination, something comes out, I beg your pardon, in examination in chief, that on the face of it might not look good for your case, for want of a better phrase. But there's an explanation. And it may be that the witness has only referred to part one of an email, for example, or only half of a conversation, or hasn't dealt with what happened afterwards or what happened before. And what you're then doing with the witness is not confronting them. It's saying to them, you said the following, but there's an explanation. This is what happened before. This is what happened after. And often there is no dispute between the witness and you in those circumstances. The witness under chief has answered the questions that have been asked of the witness. All right? If the examination in chief has been done properly, the witness hasn't been given latitude to just go off on their own mission and fill in context or color. So it may well be that when you come to cross-examine, these are just parts of the evidence that haven't yet come out. It's not that someone's hiding, it's not that someone's lying. It's just that the evidence hasn't come out, and it can come out. So what you're then doing is using the opposing witness to explain portions of the case that have an explanation. So you'll see from those three objectives that two of the three are actually positive objectives. They are constructive. They are not destructive. And that informs how you approach the cross-examination. So how do we cross-examine? We talked last week about the open questions in examination in chief. The question is what, when, why, who, how, where, explain. Those invited answers, invited detail. In cross-examination, it's the exact opposite. The time for the witness to give explanation, to give detail is done. We now put closed or leading questions. I like using the word closed because it's the exact opposite of chief. It's the exact opposite of the open question. It's a question that only allows for a yes or no answer. There's nowhere else to go. Of course, in putting those kinds of questions, as with everything else that we've talked about and which I've flogged ad nauseum over the last 2 weeks, you've got to plan and you've got to prepare. You can't put statements as questions unless you've thought about what those statements are, because obviously you've got to think about the way you frame a question to get the answer that you want. So again, it cannot be spontaneous, even if it looks like it's spontaneous. there needs to be a structured plan. Point number 3 is a big one for me. You get more with honey than with vinegar. It's an old saying. What it means is that you get more by being polite than being confrontational. Be polite as far as possible. I've been in litigation since 1996. The number of cross-examinations where I've gone in or where I've seen confrontation right from the beginning, leading to a successful outcome, are in the overwhelming minority, because what happens on a human level is that when you confront someone, they confront you. They get defensive, the arms get crossed, the body language tenses up, and they're not then prepared in any way that they can to cooperate with you. It's important to bear in mind that just because it's an opposing witness doesn't mean it's an untruthful one. It doesn't mean that person has come to do anything other than tell the truth as they know it. The fact is they're on that side of the case and you're on this side of the case. This is the side we have. It's the cab rank rule that we all follow. We take the brief. Today we're for the employer, tomorrow we're for the employee. Today we're for the union, tomorrow we're against the union. Whatever it might be, that's how it works. So we cannot assume that just because we're briefed by party A, that party A are right or on the side of the angels. It might be that they're not. And so we need to cross-examine politely, because as you do it politely, you have far more chance, number one, of remaining in control yourself. And I'll come to that. And number two, to get those answers that will allow you to explain and to underline. Also, I would suggest that if you are polite and you put questions without aggro, without tone, insofar as it's possible, there are always times when you need to, or exceptional times when you need to, you will get the concessions to undermine a case far easier if you simply put the questions in a non-confrontational way, because it's the answer you want. It's not the victory. It's not the boot on the neck. It's just the answer. I will argue the case later when the witness doesn't have a chance to explain anything. All I want to get from you is the answers. Best way to do it is to politely approach a witness who is probably expecting to be cross-examined, as the witness has seen on TV. So when you come in completely calmly, controlled, polite, it's hard for them to get angry off you, to bounce off that emotion, because the emotion's not there. I mentioned that being polite is in your interest as well. And I just want to pause there for a moment, because bear in mind, and again, this is brain chemistry, it's human nature, it's not law. When you get aggressive, the irrational increases, the rational reduces. The adrenaline pumps. The fight or flight reflex that the experts talk about kicks in. You are not in control. You are not able calmly to consider the questions, to consider the answers, to think about where it is you need to go with this witness if you're angry. And so it doesn't help you. It might look impressive to your client, but what's far more impressive to your client is a positive result at the end of the case. What I've taken to do, and it might be something you wish to consider, is saying to my clients, when I cross-examine, don't expect me to go hell for leather. It's not how I do things. It doesn't work. It's not constructive. I do it in a very calm and soft way insofar as I can. Don't be disappointed. I know what I'm doing. Just so that they're prepared and they then don't feel let down because somehow there hasn't been a performance. This isn't performance art. We're not Americans. There isn't a jury. We are forensic scientists. We are legal practitioners. Okay? And our focus in cross-examining is not to impress our client. It's to achieve objectives that benefit the client's case. Right. Why do we cross-examine in the way that we do? Put in closed leading questions. Now you'll see on the left of your screen is a picture taken from the net of a very long hotel corridor. And I would ask you to bear this image in mind when planning your cross-examination. I want you to imagine that you're standing at the close end of the corridor with the witness next to you. Just bear with me. The purpose of cross-examination is to guide the witness down the corridor closing each door on the left and the right, question by question by question, so that when they get to the end of the corridor, there's only one door left for them to go in. And by then, it will not matter whether they go through the door or they don't, because the answer will be the same. That's your objective. And it's got to be considered. It's got to be intentional. It's got to be mindful, to use the word we talked about a couple of weeks ago. So we cross-examine, putting statements, closed questions, because that is how you control the witness. You don't then allow the witness to go hell for leather and get yeah, but, and big exclamations, and I might have said, and wah, and go on and on and on. That way the witness is in control and you're not. So what happens then, if you ask the open question, and we'll come to when that happens, is you get the witness to the first door, and the witness goes through the door or sticks arms and legs in the doorway and won't go through, and you end up having a fight at the first door. You don't get anywhere near the second door, let alone the end of the corridor. So you put those statements in such a way that you get the answer you want in the sequence you want to get to the objective you want. Less said, soonest mended. The less opportunity you give the witness to explain, the better it is to explain their case, not to explain what you might need as an objective, of course, the better for you, because you're getting the answers you want in the way that you want them. You don't want to then undo all of that good work. So how does it happen then? Because we generally start, all of us, with the closed questions. What happens often, and one sees this more with the younger lawyers, and I mean that with no disrespect, I teach the younger lawyers more often, is the first couple of questions are closed questions. They've been planned that way, and then an answer comes that is unexpected, or that is not the answer that we want, or it's an answer that we don't like. And then what we do is we get irritated. So we then revert to an open question. And we get into an argument with the witness. It happens because we lose control. It happens because we've been knocked off our stride. And we've got to be aware of that. So how do we avoid this? By having our plan question by question, so we know where we are. And when the answer comes that we don't necessarily like, it's not a point at which we should panic. It's a point, if we have a plan, at which we should consider the answer and think, well, where do I go with this answer? Do I need to ask another question? Do I leave it there? Am I going to come back to it? Should I carry on with my next question that's planned, or should I move to a different theme? And all of that means, of course, that you've got to be in control of yourself. You've got to be calm and you've got to be considered so that you can make these kinds of decisions. Charity is not constructive. So when we're cross-examining, by that I mean, this is not the chance. This is not the opportunity to be nice to this witness, to give them every opportunity to fix the holes in their case. Now, you may think I'm contradicting myself. I'm not. When I say it's not the time to be nice to the witness, I'm not suggesting being impolite. What I'm suggesting is I am there to advance my client's case. I am not there to advance my opponent's case. And so I'm not going to allow this witness to go off and speak and do everything that benefits my opponent's case and not mine. I'm there for a very specific purpose, and I need to bear that in mind. Okay? So, control, control, control. It is tiring, and it takes time to plan, and it takes discipline, especially because we are by nature fighters. All people in litigation get a little bit of a thrill about litigating. It's why we do what we do and why most people don't do what we do. But you've got to control yourself. If we are appearing to be aggressive, if we are appearing to be indignant, it's got to be an act. It's got to be something that we are doing on purpose, towards a purpose, and not because we've lost control of our emotions or ourselves. Once that happens, we cannot control. And then the value of the cross-examination dissipates. Also, what often happens is that's when you get objections from your opponent, or you get the tribunal interfering. And where does that take you? It just means the momentum in the room has shifted and the witness has watched you get taken down. So they are now not in that environment where they are being compelled to answer questions that you put to them. So how do we cross-examine effectively? I've mentioned this briefly. You've got to have a plan for each witness. You've got to be clear for each witness on what your objective with that witness is. Is your objective with that witness to undermine, to underline, or to explain? Do you need to cross-examine that witness? Is there something in that case that requires an answer from you, something in that evidence that requires an answer or not? If not, don't cross-examine. Remember, even in putting closed questions, you're giving airtime, and you're also giving an opportunity for your opponent to be able to re-examine later to try and undo some of the damage. If you don't have to cross-examine, don't. If you do have to cross-examine, be clear about what exactly you need to cross-examine on. Is it material? Is it important to your case? What are you hoping to argue about this witness in the closing argument? What do you want to say? That they were truthful, that they weren't truthful, that they agreed with you, that they should be relied upon, always a joy, that they shouldn't be relied upon? You've got to know that. You've got to know your end point with the witness before you cross-examine, because in putting those questions, you're taking them to that point in the case where you can argue. You don't want to get to the point where the tribunal or the judge says, but you didn't put that, or that wasn't what you cross-examined on, that wasn't what how can you make that submission? You've got to be aware that in the closing argument, which is the roof that we talked about last week and the week before, that the roof that we're going to put on the house, that you've got to have built the walls so that you can put the roof on the house. But you've got to have an individual plan. What generally seems to work is to have a cross-examination file. And I accept this is, works far better when you're not doing this all day, every day, and you have time to properly plan for trial advocacy, to have a cross-examination file tabbed for each witness, to have notes about what you need from that witness and how you're going to do it, and to have a plan for the cross-examination. How much do you need from this witness? Is it 3 questions? In which case, just ask the 3 questions and then sit down. Remember, it's not about your voice. It's not about presentation. It's about an objective. Are there specific themes you need dealt with? Identify what those themes are so that you know when you're working through the theme, and most importantly, when you've got to the end of that theme. We've got to resist, just as an examination in chief, the instinct that we have to ask too much, especially when things are going well and we feel bulletproof, to keep asking questions, to keep pushing. Sometimes you've got what you want. It's almost unbelievable that you have. Trust yourself. If you planned, you'll know. And then sit down. Job done. And consider or ask this question: how can I keep it as tight and as short as possible? What this means, as often applies in examination in chief as well, is isolating how many questions I need to ask. Now, not being so brief that I'm jumping from point 1 to point 7 because I'm trying to be brief and look like I'm this, surgical scalpel that gets 3 questions and sits down. Very impressive. I'm not talking about that at all. What I'm saying is consider, do I need to ask 15 questions of this witness? I've got my questions, I planned them. Do I need all of them? Are the first 5 just rehashing the witness's evidence that they've just given? So starting by saying, in your examination in chief, you said this, and then you said this, and then you said this. Now, those are closed questions. Sure, only a yes or no answer. But do you need to? They've just said that. They've just given that evidence. Why are you reminding them of it? If there's a purpose to that, fine. But then you're doing it not because it's an automatic response or the way you always cross-examine. You're doing it because you mean to do something by it. If you can avoid that, avoid it. Keep it as tight as you can. Again, the less you cross-examine on, the less is available to re-examine on. So you've got to always be in control. You've got to always be properly in the driving seat, and not just with your foot flat on the floor, swerving all over the highway because you're battling to control this very powerful vehicle. You've got to retain that control at all times. So let's talk about courtcraft. You've got to be disciplined. I've flogged this morning. You cannot, if you're going to cross-examine successfully, lose control, which means you need to discipline yourself. Stick to your plan, but don't be inflexible. Again, an apparent contradiction, but not so fast. What I mean is use your plan. You've put the time in, you've thought about it, use the plan, but be flexible. Answers are going to come that might not be the answer you planned or intended. What so often happens is a witness will say, well, yes, but, or can I explain? And immediately we go, just say yes or no. Just answer the question. Most times, as long as it's not a process, a practice that the witness is giving to obviously be evasive, in which case the tribunals generally get involved and agree with you. But if a witness needs to explain an answer, even though you've put it in the format of a closed question, most often the tribunal, the bench, will allow the explanation. So avoid the conflict by going, the first couple of times at least, just answer the question, just say yes or no. Because all that will mean is the judge will go, no, I want to hear what they have to say. Then listen. Because more often than you realize, something will come out of that explanation that will be useful to you. Also, if there's something there that isn't useful to you, by just allowing them to talk and moving on to the question, you provide less emphasis, less of a spotlight on that part of the evidence that allows you to move on. So listen. Don't just, as we talked with Chief last week, throw out the question and wait for an answer. Listen to what that answer is. Consider the answer. Litigation, as you've all experienced, is exhausting because this is mental agility all the time. But if the answer means that you don't have to ask the next question or the next two questions, don't ask them. Don't ask them. If those questions become irrelevant, ditch them. If you've got the answer you need in 3 questions, not 10, great. Know that you've got the answer and move on. Conversely, if the answers mean that you have to canvass the area, do so. But be kind to yourself. Be careful. Don't be afraid to ask for a few minutes to stand down, to think about something. Nothing wrong with that. Rather do that than blunder hell for leather into an area that you haven't really thought through yet. Because what that means is that you're not completely in control of the plan or the narrative, and you're not sure where it's going to take you. Be kind. Take time to settle yourself down. It might be that something comes as a bit of a surprise. I'm not suggesting you can stand down every 5 minutes, but if something comes and you need time to just think that through, think where it goes, think what you want to do about it, say to the tribunal, can I have 5 minutes to stand down to consider this? Or make a note of it and leave it to the end of your cross-examination. But don't just respond viscerally to an area that you haven't thought about, because inevitably it will blow up, which leads to the next point. Do not argue with the witness. That's not cross-examining, that's arguing. And the arguing happens when both of you are cross. So if that is where you've got to, and blow me down, we've all been there, we all do it far more than we'll admit, it means you're not in control. It means your emotions are taking over, not your rational side. And you're not then advancing your case. You're now in a personal spat with this witness. Let's just ask the basic question, why? Why does it help? Does it advance the case? Does it help you advance your narrative that you want to advance? You are not there to argue with a witness. You are not there on behalf of your client to give a right uppercut to the witness's cheek to make your client feel better. That's not our job. Our job is to be the calm, controlled, objective practitioners, which means we have to remain in control. Do not ever lose your temper. Easier said than done. We are in a pressurized situation, trying to get the best that we can and do the best that we can. I accept that unreservedly. But again, once you lose your temper, you are not in control, which means you cannot cross-examine coherently. Your cross-examination either goes off the rails or it gets so clouded by disputes with the witness, comments to your opponent, whatever it might be, that you don't ask proper questions that you still need to ask. You allow the whole cross-examination itself to be obscured, so you don't know where you are in this, because now your focus is on fighting. It's not on advancing the case. And those of you who've had the fortune or misfortune of reading review records, for or against, or as someone who presides, will know. You can see it in the transcript when cross-examinations go off the tracks, and there are these sarcastic remarks getting thrown between the opponents that a commissioner or a judge has to control. It just means that the cross-examination doesn't advance, and frankly, the witness gets let off the hook, because now they're not being put under pressure in a coherent, considered, controlled, forensic way to answer questions. Now it's just two human beings going at each other. Remember the judge. Remember your objective. As we talked about last week, this is not a bilateral conversation. It's triangular. It's tripartite. You need to ask your questions slowly. You need to ask them coherently so the judge, number one, can get the questions and the answers down, because that's what you want. Number two, can follow. And number three, more importantly, can start to get a sense of whether the witness is being cooperative, is being evasive, is not being truthful. That will allow you to argue what it is you need to argue. The judge has taken the notes of the examination in chief. You need them, especially if you're explaining, undermining, and even if you're underlining, to get what you're saying. Otherwise, it's a waste. If it's just question, answer, question, answer, question, answer, question, answer, because you're pumped and the witness is answering, but the judge can't keep track, you've wasted your entire cross-examination. You're not there to prove anything to the witness. You're there to prove stuff to the judge or to the chairman or to the commissioner. Remember that objective. The purpose is to get sufficient from that witness to either undermine, underline, or explain. That will allow you successfully to argue to this person at the end of the case. So you need them on side. You need them listening. You need them following. And get in, get out. A perfect analogy is if you consider, for those of you who lived through it and those of you who didn't live through it, who no doubt have learned history, of when the Americans went into Iraq in 1990 and when they went into Iraq in 2001. In 1990, Saddam Hussein had gone into Kuwait, they invaded Kuwait, they got him out of Kuwait, back into Iraq, and that was the end of the case. There was an exit strategy. It was in, it was out. There were minimal casualties, minimal cost, objective reached. Went into Iraq in 2001 without a plan and only pulled out about 12 years later. Massive casualties, objectives not achieved, a huge waste in blood, in treasure, in you name it. It's the same in cross-examination. Know what you want, have the plan, get in, get the plan, get out. Control that instinct that we have to land the punch, to get that last little point in. It's not what we're there to do. If we've got the answers we want, we've got the answers. Great. Then leave it alone. Bear in mind, this is intentional. This is objective, and we need to know when we've achieved our plan. Once we've got there, we've got there. If you go on a road trip from Johannesburg to Cape Town, once you get to Cape Town, you stop driving. You don't then drive around because you like driving. You've got where you need to go. It's the same here. Okay. Let me finish the sharing. There we are. A 35-minute journey through different ways, perhaps, to approach and to consider cross-examination. Remember, ultimately, cross-examination is a tool of advocacy. It's not a weapon in the sense that you want to hurt or wound. It's a tool you want to use to advance your case. This is one of the 4 tools we have. We have an opening address, we have examination in chief, we have cross-examination, and we have a closing address. All of those have got to be utilized correctly in the right sequence for the right reasons to get to the right result. If you've done that, good for you. If you don't know what that result is, think again. Right. Any questions? Anything anyone would like to ask about cross-examination?
There are some questions on the chat. Don't know if you can open it up there, or if you'd like me to read them to you.
Let me open it up. Okay, Nakedi, how do you deal with a witness who is evidently misrepresenting facts? Yeah, this is a tough one, because in my experience, certainly most witnesses don't. They don't misrepresent the facts. There are very few witnesses who lie, I have found. Mostly they haven't remembered, or they've left out stuff, or it was a long time ago. If you catch a witness in that kind of contradiction where they're misrepresenting the facts, best way is calmly to deal with the witness and say, well, you said the following, but then establish through putting an email, putting a version to demonstrate that it's misrepresenting. Do it calmly and do it coherently. Don't rush that. Often it takes time to establish the contrary version so that you can ask that final question or put that question that the witness has therefore misrepresented the facts. Be very careful in doing it. No tribunal likes to hear witnesses being accused of lying, and essentially all that happens then is you have an argument, because no witness is going to say to you, yeah, you're right, I actually was lying. They're going to get very offended, and now they can hide behind the being offended thing to not answer your questions. So if that happens, think to yourself, okay, they're not advancing the case that I think they should advance, or the true facts. Let me build, put the questions, close questions, one after the other, to get them to the point where it's quite obvious that they've misrepresented those facts for whatever reason it might be, before you land the next question. Before you land that question going, I put it to you. That phrase makes me chril. I can't stand it. I don't think it does anything to say, I put it to you. Every question, we're putting something to someone. That's what we do. But don't rush into this, and don't be offended by it. It might be that the witness is taking a chance. Our job's to catch them. Best way we do that is calmly, to know our documents, to know what there is, and to say, okay, well, let's go. One by one, question by question, that can only be answered in one way. And then you get to a conclusion where sometimes you don't even need to say to the judge, the witness is misrepresented, because the judge is listening and can see what's happened. But if they are absolutely untruthful witnesses and you've caught them in that, again, don't go into battle. Just put to them, you know what, this is the second or the third time that you've been untruthful, that you've been caught being untruthful. And I'm going to argue that the court should disregard your evidence and find you to be untruthful. Calm on anything and move on. And then argue that point later. The approaches in cross-examination can be destructive or constructive. How do the two approaches differ? Well, they differ in depending what it is you want to do. So if what you want to do with the witness is underline aspects of your case or explain something, then you're going to do it in an intentionally non-confrontational way to get the best out of that witness. You want them to be your friend. You want them to feel that you're this nice guy, that they want to help. Because like I've said before, most witnesses are lay people who've never been in courtrooms. They're not there to mess around. They're there because they have to be there. And if you can get on their side and get them to answer the questions, they're going to answer the questions in the general sense, in the ordinary course. The destructive cross-examinations where you're undermining, I would suggest your approach doesn't change. Because if you go into it confrontationally, the witness seizes up. You would far rather be in a position where at the end of the cross-examination, the witness thinks, oh God, what if I just conceded? Or wow, how did that happen? Where they couldn't but answer the questions as you want them to answer them. So I would suggest to you, Nakedi, your approach doesn't change. It's calm, it's polite, it's controlled, it's considered. Nothing wrong with smiling at the witness. I don't mean that sort of smarmy, sarcastic smile, but just, I'm not here to fight with you. I'm just here to ask questions. That's what I'm going to do. And then at the end of it, the witness realizes, or doesn't sometimes, that they've given you the concessions you need. Get it in that way. Like I say, you'll do a lot more with honey, even if you're trying to undermine. Donald Charlie's, what impact, if any, when you don't cross-examination and two versions remain? When I say don't cross-examine a witness, I immediately have a shiver that runs up my spine, because I don't want to suggest that this is something you should often do. Most witnesses do have to be cross-examined because they've advanced something. That's why they've been called. All I'm suggesting is know what you want from the witness and know why you're there. But if you don't cross-examine a witness, that means the factual version that they've advanced remains undisputed. Now, that might not be a problem for you. But if it is going to be a problem for you, if there are parts of that version that need dealing with, then you have to cross-examine. But again, then you know what your objective is. You know why you're there. You're not just cross-examining because the examination in chief is finished. You're doing it to do something, to explain, to underline, to undermine. But if you don't cross-examine, then you run the risk that a judge says, or a commissioner says, well, none of that was disputed. If that's okay for you, fine. If the witness gives evidence and you listen to it and you think, but that's cool, I like that evidence, that's perfect, cool. And when the judge says none of it's disputed, you say, well, yeah, correct, but let's talk about what they said. Yeah, I hope that helps. Sagir, can you briefly discuss re-examination? The best advice I can give you, Sagir, and everyone about re-examination is don't. Re-examination is, it's a difficult little beast, that one. The purpose of it theoretically, let's start there, is to deal with aspects that arose only in cross-examination so that you can clarify things that might require clarifying. Because obviously, if you have a considered opponent who has put things in a certain way in leading questions, it can create an impression. And obviously, that's what we want to do in cross-examination. So in re-examination, we get to deal with those issues. But invariably, what re-examination becomes is an attempt to repair the damage, and an obvious attempt to repair the damage. So what we end up doing is focusing on the very areas of our case where there are weaknesses, where there are holes in our ship that are taking on water, and trying to plug those holes. Now, if you have to do it, you have to do it. But the general effect of it is that you bring more attention to the weaknesses because you're trying to fix them. So if you don't have to re-examine, don't. If you have to re-examine, bear in mind it is very limited. It's only on aspects raised in cross. You cannot advance new evidence. You cannot use that as a second bite of the cherry to get out evidence that you forgot about. And be sure that you know why you want to re-examine. Again, same thing with chief, same thing with cross. You've got to be mindful. So when that witness has been cross-examined, sometimes the best thing is to just get the witness the hell out the witness box. Sometimes the cross-examination hasn't been so bad. Often. And there's no need to re-examine. Everything's cool, fine. It also projects a confidence in your case if you don't re-examine. No, there's nothing to do. I'm happy with this witness. But if you have to re-examine, think carefully about why, think carefully about how, and focus just on those areas that in re-examining advance your case. You know why you're doing it. You're asking just the questions you need to ask. And that don't make the judge or the commissioner look at it and go, yeah, no, my friend, you're making it worse. So it's a very, very difficult part of the case, because our instinct, especially when there's been a successful cross, is to try and repair the damage. Sometimes you can't repair it. Sometimes it's not as bad as you think. Sometimes the witness is just in such a state that you're not going to get anything coherent out of them anyway. All of these are real-time considerations that you have to make in a split second. I totally concede, but just be very mindful and careful. And again, avoid the need, the desire to put leading questions in re-examination to say, well, you said this in cross, but didn't you actually mean this? You can't do that. You're going to merit objections. It's not going to be allowed. you still have to ask the open questions. So you're now got a witness who's just gone through cross-examination, who's tired, and let's not forget that. This is exhausting for us. It's doubly exhausting for a witness. So are you going to get the best out of this witness? Are you going to get the best answers in the best way out of the witness at this point? You need to be aware of all of that. But why do you re-examine? Only to clarify aspects that arose in cross. It's as limited as that. Are there any other questions?
Did you address the one from Donald Charlie's? What impact, if any, when you don't cross-examine? Did you?
Yes, I did. I did.
Sorry.
Yeah.
Okay, then that looks like it.
All right. Well, thank you, everyone. I hope you have a good day going forward and a good week and a much better week. And we will see you next Tuesday for preparation and delivery of argument. Okay, go well.
Thanks, everyone.
Thank you.